Let's bring in Caroline Polisi. She is a former criminal defense attorney, a federal criminal defense attorney, and an adjunct lecturer in law at Columbia University. Caroline, thanks for joining us. We do expect the opening statements to begin in just a couple hours. Remind us, how important are those presentations as they set the stage for the jury?
So important. Really, it's one of only two times, the other being which of closing arguments, when prosecutors and defense attorneys are going to be able to address the jurors face to face. And as Shaq laid out there, prosecutors here are going to make that roadmap here. They are going to really home in on two things are at issue in this trial: cause of death and Derek Chauvin's intent. And if I'm a prosecutor, I am going to set aside 8 minutes and 46 seconds of my opening argument for silence in that courthouse. And that represents the amount of time that Derek Chauvin's knee was on George Floyd's neck. And the point being that 10 minutes or 10 seconds of silence in a courtroom is uncomfortable. 8 minutes and 46 seconds is going to be unbearable. Now, if I'm the defense, I'm going to try to pick apart that argument. They really do have an uphill battle here with respect to that video evidence that everybody has been talking about. They're going to try to make a bit of a water isn't wet argument, which is that the cause of death wasn't what we have all seen now, which is the knee to the neck on George Floyd. They're going to say that they're going to put on defense experts, noting that the cause of death actually was not the knee to the neck, but rather was the amount of fentanyl in Mr. Floyd's system at the time, methamphetamines, an undiagnosed heart condition. They're going to say that all of those issues were more contributory to Mr. Floyd's death than the knee to the neck. And so, the question is whether or not both sides can lay out those arguments, tee them up so that at closing arguments, they can then deliver on those promises to the jury. Jurors like to feel like they have not been lied to, and they like to see prosecutors and defense attorneys delivering on those promises in opening arguments.
Caroline, we know that Chauvin's facing second and third degree murder charges plus manslaughter. So how might the prosecution try to make their case?
Right. So the prosecution has three different bites at the apple, as it were, here. Remember that top charge here, murder in the second degree. It's not an intentional murder. It's a felony murder theory, which is that they will have to show that during the commission of another felony, in this case, it's going to be an assault on George Floyd, during the commission of that felony that he died. And so that's the top charge here. It carries with a maximum of 40 years in prison. The prosecutors really lucked out here in that recently the third degree murder charge was reinstated. That's a different theory. It's sort of what we call depraved indifference theory. And the judge initially dismissed that charge, but has now brought it back. The idea being that typically in Minnesota, it's used to charge in the case of conduct that showed a reckless disregard for human life in general. So the classic example is firing into an open crowd. You didn't have an intention to kill anyone specifically, but obviously your actions showed a depraved indifference to human life. So that's the middle charge here. As you noted, the lowest charge here is manslaughter. And the fact is, the eyes of the world are watching, and a manslaughter conviction just isn't going to cut it for the prosecution. They want to see murder in that charge. They want to see that they've gotten a conviction on murder. It might be hard. There are technical issues with those murder charges, but they have several chances. So that's probably good for the prosecution.
And quickly, you did touch on this, but what is the defense likely to argue?
So again, the defense is likely to argue, one, that the cause of death was not the knee to the neck, that there were other contributory factors, and they're actually trying to bring in evidence. They asked the judge if they could bring in evidence of Mr. Floyd's prior bad act, as it were, which could be seen as highly prejudicial, but they want to show that he has a history of resisting arrest. They want to show a prior incident in 2019 between George Floyd and Derek Chauvin in which he resisted arrest, he ingested drugs immediately prior. So they're going to try to show that this was Mr. Floyd's MO. They're also going to try to show that Derek Chauvin was acting reasonably with respect to his police training, that he was allowed to do what he did, and that he acted reasonably under the circumstances, all sort of difficult to prove in the face of that video.
All right, Caroline, thank you so much for your expertise. Appreciate it.
Thank you.
Hey, NBC News viewers, thanks for checking out our YouTube channel. Subscribe by clicking on that button down here and click on any of the videos over here to watch the latest interviews, show highlights, and digital exclusives. Thanks for watching.